Hey again, and happy 4th of July 2022. I'm going to celebrate by doing a video. It's my little piece, my little part to the overall effort, and I'm happy to do it. And today we're going to talk about traffic ticket story hour. And the moral of the story may end up being exception, acquittal, discharge. Some things you really want to happen if you're going to go to all this trouble, right, to go fight a traffic ticket. Which I believe everybody should. That's what you should do. You shouldn't just pay them because it's easier. You should make them prove they have authority, or they'll keep doing it to other people. So that's where we are, right? Traffic ticket story hour. Fact, fable, or fantasy. Well, one of the facts I'm going to show is back in 2017, I helped a guy get a dismissal on a misdemeanor traffic case that one of the citations, although improperly cited, but one of the citations was for an insurance statute that was a misdemeanor for not having insurance that had a 1 year, misdemeanor charge on it. So, it's a big deal. It's not just pay a fine. These are misdemeanors they can put on that ticket just as easily as a civil infraction. And then if you don't show up, well, that civil infraction, then, no matter what you had before, what you thought, because you didn't show up or didn't appear, they're going to put you in contempt of court. Well, that's a civil infraction. And once they got you in civil contempt of court, they can hold you for the rest of your life. Don't have to until the contempt has been discharged. You're in contempt, right? So it's real important to get, shit discharged, not dismissed. See, a dismissal, as we'll see in this video, is, it's a half step. It's like a summary judgment, and it can be overturned. And so I have a lot of documents from that case, and what we had actually done was I wrote a letter for Billy to send to the Supreme Court, Chief Justice, who's in charge of the administration of justice, in the state of Michigan, complaining, blah, 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 which got returned with the reply, and then we put it into his court case, and from that point forward, his court case was different. Although when you read the reply, it's like, the Supreme Court wasn't going to do anything. So anyways, I'll just say it when we get there. So my point is, I have that, and there's some transcripts that go with it. And because of what Billy was doing, he was getting the show trial, and they spent a lot of time at it. And so these transcripts are, 35, 40 pages long, which, is quite long for a period of time in court on 3 different occasions. So they used up all sorts of court time to do this, is my point. And I've seen them do the same thing before for other people when they were, basically giving them the win without telling them they were giving them the win. Right? They gave them a show trial. They did it to Rosita in Illinois in her case. And, at the end of it, the judge said, they find her not guilty. Case dismissed. Right? Not guilty. Well, that would mean you're guilty. Still, the case was dismissed. So, it's just, and then they actually put the recorder on the stand and put her under oath, and they did all sorts of, it was, like a whole afternoon in a court case to dismiss a proceeding. And really the reasons that these things had happened was because letters were sent to, in her case, to the chief judge of the circuit court, or, like I said, or send it to the Chief Justice of the Supreme Court of your state. So if I was going to do it to anybody, well, that's who I'd send it to, right? Just send it there and then put it in your court case. And we'll get, so let's get around to that. Okay, so hey, I'm Staff Sergeant Robert Allen Rutluski, U.S. Army veteran. And for all veterans, please be aware, you're still in the military. Don't let them take your rank from you. You've never been released. You're actually still getting paid. You're just not collecting it. It's going into a fund, and they're living off the interest right now, but at some point, they want to collapse all that shit and take the principal. Right? So, a DD-214 is not a discharge order. And like on mine, it says on there that I did not receive dental within 90 days. And dental is part of medical, and you can't discharge unless you have a complete medical examination prior to discharging, and, on and on and on. So there's just all sorts of things. My point is, we're still in the military. And the United States is under martial law, and it has been since 1863, right? And so every place you see a gold fringe flag, the Army could use this coercive force to get them people in that office to do whatever the heck they wanted done, right? But the problem is that disconnect's been made, and we're not going to the window to talk to the Army. Because since we haven't been discharged, we would be like the civil authority out in the field, the eyes and ears of the commander-in-chief about the peace and tranquility of the district, that he's responsible for. It's a wonderful system. We don't need Congress. We don't have a Congress. Nobody in Congress has taken a proper oath of office. We haven't had a Congress since the Civil War. They read all these laws, but they're really not the Congress. They're the administrative state, United States of America, but they're not the Union, United States. And I want to go back to the Union, because that's where all the protection is. That's what's under the Constitution. So, we got to crack the egg, pierce the veil, find the Achilles heel, be the hobbit that shoots the arrow into the missing scale on the dragon, all that stuff. You only got to do it once, and the whole system will collapse. Be Toto. Pull the frickin' screen back. Okay, so enough jibber-jabber. I am Staff Sergeant Robert Allen Rutluski, U.S. Army veteran, also known as Rob Ryder, R-O-B-B-R-Y-D-E-R. My email address is courtofrecord@AOL.com. And like I said, this video is going to take a while, so you might want to, mentally prepare yourself or pick a different time to watch it when you can pay attention, because I'm going to go through a lot of stuff that, if you're into this kind of stuff, is, it's one of a kind. Right? You won't see it unless you see it here. So let me get going. Hang on just 1 second. And one final thing then. So on Rob Ryder, R-O-B-B-B-R-Y-D-E-R, with 3 B's on YouTube, right? My last 2 videos have to do with what I'm going to be talking about now. So you look at this as a trifecta. And so traffic citations, dirty little secrets exposed, and then uniform law citations, Ohio Mayor's Court. I'm really curious. Like, this one's got 13,000 views. And all these other ones, 1.1, 2.3, 1.2. Here's one, 9.2. Now, why is that? Is it because I use the word traffic? Or am I being shadow banned? You just don't really know sometimes. But there you go, right? So somehow 13,000 people watch this video, so they should watch the next one and the one I'm going to do right now if you watch the first one. That's the way we roll. Okay, hang on. Okay, so in this video, I'm going to be jumping around between something that happened in 2017 and something that we're going to be trying now based on what happened in 2017, right? So, but to start with, hey, this is the order, right? Here's the fact. Here's an order of acquittal, dismissal, or remand. And the box that was checked was defendant's motion for dismissal is granted, without prejudice, and the case is dismissed. Right, so there you are. Right, what was it? No valid license in possession. That was the crime. So they called it a crime. Although I believe it's only a misdemeanor of 93 days or less. I'd have to go look. But there were other charges also. Right, this is only one charge of 3 that was listed on the traffic ticket. But this is how they did it. So count 1, versus count 2, and count 3, they're not on there. But it was, and Billy's never been bothered since then, so they just decided to leave this one alone because he took up a lot of their time, right, to end up giving the man a dismissal. And what I would say now is, having looked at this, what I know today is we don't want a dismissal. We want an acquittal, right? An acquittal has a much more powerful definition than a dismissal, because a dismissal really is just a summary judgment. But an acquittal, so now if we're saying, okay, it's traffic, and really traffic has to do with commerce, right? Traffic is a commerce word, so that would mean to do with contracts. So we could say it's acquittal contracts, a release or discharge from an obligation or engagement, right? So, okay, I want an acquittal, right? From whatever it is we're doing here, I don't want to play, I want an acquittal. I don't want it dismissed. But if there's a criminal law, which, was a misdemeanor they was being charged with, well, absolution of a party charged with a crime or misdemeanor. So I'm just saying that That's what we should have asked for, because what they gave Billy is what he asked for. He asked for a dismissal. He didn't ask for an acquittal. And as we'll see when we read through some of the sections in the transcripts, the judge is telling Billy, so I can give you a dismissal, but it's only temporary. And Billy's question, well, how do we take care of that? Because that's not what he wants. But they go on to something else, and they come back around, and it comes back the same thing. Well, I can give you a dismissal, but it'll only be temporary. He's just not telling Billy, well, how about if I give you an acquittal instead? And Billy isn't using those words, so that never gets said, right? But somebody could put that on the record, and well, then the record would say the man asked for an acquittal, which is the proper thing for a malicious prosecution, which this is, right? So, and to understand that better, if you have, didn't watch the other two videos, well, I'll show you all the little shit they do in these, all the different little tricks, right? Dirty little secrets exposed. What happens in a traffic citation? So, yeah, hang on a second again. Okay, so again, right now I just go through some fact stuff to get this out of the way, and then we'll get into story time. So, and then the bond is canceled, right? Well, so they dismissed the case and gave him back his bond money. Well, sure enough, right, here's a check for $300, right? Bond refund from the 64A District Court Trust and Agency account. Right now, as we can see, that says 64A District Court. But we look at the envelope it came in, it says 64A Judicial District Court. Yeah, I wonder if they're using the same address, 101 West Main Street, Ionia, Michigan. Here they spell everything out, right? 101, the W is not, and then Main Street is, right? W is abbreviated, West, and Main Street is all spelled out. Ionia, Michigan. Spelled out with the 9-digit zip code. Right, the Edon. So this is like a physical address with the mailing address attached to it. Physical and mailing address, because this is the building right here. Right, so I mean, that's the proper way to do an address in that jurisdiction, but that's not the way they ever do our address, so we're really not in that jurisdiction. They got us in this abbreviated jurisdiction of the administrative state, but, Michigan was broken into judicial districts. And so every court, if it had a name, should say Judicial District Court. I could accept that. But what they say is 64A District Court. And, there's not 64 or more district courts. There's only one district court that has many judicial districts. And so it's a really big fucking deal, the way that they, use their terms. And, of course, they're using them to scheme and so forth on us. And, well, I'm just showing evidence of it. All right. And then just real quick to show, because the ones I may show that are actually filled out may not be this clear, but this is, an example of a state of Michigan uniform law citation. Any state's going to have something, whatever they call their ticket, right? Look at the top, there'll be a name on it, Google it, and you'll start finding all sorts of information on it that you didn't know before, right? Which is how I found it. I got a ticket one time, or somebody sent me one, I said, well, let me Google this and see what comes up. And now I know all sorts of shit about uniform law citations, because I took the time to look the word up. But they never show you this, right? This is the backside of the citation, right? And it says it's a district court register of actions. And so that doesn't say 64 district courts. It's just the district court. So that's proper, right? And so anything that happens is supposed to be listed on the back of this thing. You're supposed to put the violation in here, what the bond is. And then what I wanted to show now, just to we'll move on, is this thing about plea, right? Where they have guilty, not guilty. Mute, you're going to be not guilty. No contest. Admit with the explanation. But you have this one, deny. Deny, deny, deny. So when you plead to a ticket, you should deny it. Because by denying it, then you make them have to bring everything in under oath. Right? So it's, if you plead guilty or not guilty, they don't have to swear to anything. But if you deny, now they got to swear to everything. Now people have to come to court, be put under oath, and, yada, yada, yada. you'd have to go to trial. So, because if you plead guilty or not guilty, you're doing that as a defendant. And if you're the defendant, well, you're guilty. It's really that simple, right? You wouldn't be the defendant if you weren't guilty. They were supposed to have already investigated this. Okay, so that's they don't ever show this, and so this copy that has this side on one side and this side on the other is supposed to be given by whoever gave you the ticket to his boss, the police chief, who within a certain number of days is supposed to mail it by United States government mail to the court. Right? That's what it's all that is written into the Michigan compiled law for the Michigan Vehicle Code. But none of that's happening. Right? They're not doing that. They're emailing these to someplace. Well, that's not written in the law, so that, because they're not doing it the way that it says to do, would be an exception. So let me find this thing exactly. Hang on a second. All right, here's the Michigan Vehicle Code. What's supposed to happen with a citation, right? That the police chief or person duly authorized by the police chief shall deposit the original of the citation with court having jurisdiction over the offense not later than 3 days after the citation, excluding Saturdays, Sundays, and holidays, so 3 business days. The citation shall be considered to have been deposited with the court as required under Section 1 if the original of the citation is mailed, didn't say emailed, mailed not later than 2 days after the date of the citation as specified under the subsection. Mailing shall be accomplished by closing the original of the citation in a sealed envelope, first-class postage, fully prepaid, addressed to the court, and depositing the envelope and contents in the United States government mail. Now, I'm pointing this out because if you're in Michigan, it doesn't matter how you got your ticket or what it says. This is the thing that they're not doing. This would be an exception because they didn't do what the damn Michigan Vehicle Code said to do. And so, as an example, in the case that I'm helping Nate, who's mainly in the other 2 videos, I'm showing a lot of his documentation with his ticket. All right, it's got these 3 allegedly state laws that were violated, but none of these are a proper citation for a Michigan compiled law because you don't have the MCL in front of it. And then one of them, this 53102, well, this is a 1-year misdemeanor, and so it's not supposed to be on this. Well, I'm not saying it can't be on this document, but for any misdemeanor greater than 93 days, they have to file a separate criminal complaint. Right? This is all written in, the findings of the Supreme Court, and they're not doing it. So, another exception, right? That it's not being done right. And then on here, it said to go to the 72nd District Court, Marine County. Well, again, there's only one district court, so it could say 72nd Judicial District Court. But, saying that it's that court, Marine City, well, that's, that court doesn't exist. And, not in the United States. It's not a constitutionally allowed court. Right? Because the judge of this court didn't take an oath to satisfy the 6th article of the Constitution, United States Constitution. He didn't take the proper oath to satisfy the Michigan Constitution because he didn't use his full legal name. And, there's all sorts of errors. Now, like in Ohio, I showed, they're supposed to go and get they have to actually have a commission. So it's not just the oath they have to have a commission first before they can go take the oath. And it's a commission from the governor. So these are all exceptions because they're not doing what the law says to do. Right? And I'm just showing you the proof. So this is what his said. Now, because I had done those other 2 videos, I had Nate contact the state police and say, well, ask them what they did with the, with the citation. And so this was the answer. Thank you for contacting your Michigan State Police with a question of how to adjudicate your traffic citation, X, number, da-da-da. The court address you requested is, well, he's using St. Clare County District Court with this address. Right? Well, that's not the address. It's, where'd the ticket go? Okay, there it is. That's not the address, the name of the court here. Here's the 72nd District Court. So the cop is saying, well, I should have mailed it here. But due to advanced technology since 1984, when that was last updated, traffic citations are now issued electronically, allowing for immediate data transmission to the court holding jurisdiction. But that's not what the law says. It doesn't matter that you can use email, then you can do it that way. The law says you got to put it in U.S. government mail. It's not a letter, it's U.S. government mail, which would be a fracked letter. They'd have the stamp up in the upper right-hand corner instead of a stamp. A stamp that says they have some kind of exemption number, permit number or something like that, and that's U.S. government mail, prepaid. So now we have the guy that's apparently the commander of the Lapeer Post, the Michigan State Police 3rd District. Right? Now this is what he's calling himself. Right? Saying that he didn't follow the law. Because the law says the citation shall be considered to have been deposited with the court as required under subsection 1 if the original citation is mailed. First class postage, fully prepaid, addressed to the court, and depositing the envelope and contents of United States government mail. That didn't happen. And he says if he had done it right, he'd have sent it to a different court than the court that's on the ticket. So we got all sorts of things that are wrong. Right? Exception, exception, exception. I want an acquittal and discharge. Right? There's your answers. Now we got to convince the court. I'm just showing you where the frickin', where the easy, low-hanging fruit is. Instead of worrying about what they said you did, bitch about what they're doing. Okay, so, and then in another section, now again, every state's going to have some kind of, vehicle code. So this isn't, what I'm showing you is Michigan's, obviously, but, you can go look this stuff up yourself. Right? Whatever they call your thing. Start with citation. And see if you find citation with maybe your state. See where it takes you. See if you can find the code like this. Get a PDF. You can do word searches. And pretty soon you'll have found the 2 or 3, sections of the vehicle code that you're going to take exception to because who's ever doing this to you isn't following the vehicle code. Right? You're taking exception to the proceeding. So this says, for the purpose of this act, a complaint signed by a police officer shall be treated as made under oath if the violation alleged in the complaint is either a civil infraction or a misdemeanor or ordinance violation, for which maximum permissible penalty does not exceed 93 days in jail or fine or both, and occurred or was committed in signing officer's presence or under circumstances preventing the officer's insurance of citation under these other sections, and if the complaint contains the following statement immediately above the date where it's done the penalty of perjury. All right, that's what it can be used for. Didn't say you could use it for over a year. Well, or for a misdemeanor that is greater than 93 days. So, that's what they're doing whenever they say no insurance. You go look up that statute and it says it's a misdemeanor greater than 93 days. Well, that's an exception. Okay, so then, right, in 2003, the Michigan Supreme Court put out a memorandum, right, and it's still on their website, talking about these things to do with the uniform law citation, and which it said that filing a formal sworn complaint, the uniform law citation is the formal sworn complaint, as is a DC 225. The court may require a prosecutorial review of a citation or the filing of a formal complaint on Form DC-225 as a matter of preference for purposes of ensuring that the complaint has been reviewed by the attorney or by an attorney. Because the law citation is a complaint, but you're not supposed to put things on it greater than 93 days. But it's still a complaint. Greater than that goes on this Form DC-225, and on there has a place for the prosecutor to sign. Right? This is a non-requirement of statute, MCL, something or other, authorized process for filing a hearing, citation alone, not intended to require the filing DC-225 before the court. That section, though, was intended to allow for an option of proceeding on either an appearance ticket or 225, depending on the preference of local jurisdiction. The primary point of MCLs is to ensure the court does not proceed until the citation or sworn complaint has actually been filed. Well, we just saw how, where the proof is according to according to the hang on a second. According to this right here, right, that the proof, right, is that shall be considered to have been deposited when it's done this way. Well, they can't say that because of the way they did it, so there is no way to say it's actually been filed. Had it been sent to the mail using United States government mail, and it wasn't. Hey, there's an exception. Violations of the maximum penalty over 93 days. Some law enforcement agencies issue appearance tickets for 1-year misdemeanor violations, such as possession of marijuana in conjunction with motor vehicle violations. This MCL limits issuance of citation to a violation with a penalty which does not exceed 93 days, and it prohibits issuance altogether for some offenses. The use of uniform law citation may reduce the likelihood that defendants are fingerprinted when required, thus reducing the competence of the criminal history or completeness. The uniform law citation may not be used to substitute for a prosecutor-issued criminal complaint for any violation with greater than 93 days. Courts receiving such citations, which is what this one is, all right, courts receiving such a citation, got one on there, greater than 93 days, may not open a case until a complaint authorized by the prosecutor is received. Citations for violations with the penalty over 93 days should be treated as if marked authorization pending. And all these things happen in Billy's case. This is I'm showing them right now. Is when we get into the transcript, all these things will have happened, right, and have been brought up and discussed a little bit, and learn what you can. Okay, so hey, this is Billy's. This is one from 2017, and you can't read these very good, but you can see this as proof of insurance. Well, that's one that would be over. It'd be a 1-year misdemeanor. It's no different than the one Nate has that says no insurance. Well, there you go. Although Nate has one other thing, right? That no insurance, operation without security. He didn't put security down, right? Because it's got a slash. It could be either of those. He could put operate with security, and that's where you put something up with the like a bond or something with the Department of Treasury. All this is written in the vehicle code, right? That you could put up some kind of security, and maybe then you wouldn't have to have insurance, which I've shown before that if you get general liability insurance, that certificate with the vehicle number in the right place given to the Secretary of State will is supposed, and it did work for a guy in Arizona. I've not tried it here myself, but he did it in Arizona. They'll accept that as the insurance for the vehicle, right? So you don't have to have separate no-fault insurance. Your general liability insurance policy with the proper numbers, amounts, put in the vehicle as an additional insured, or it needs to go in the description someplace. I'll be doing a video on this again soon because I am going to try it with a vehicle. But, that's supposed to act as your insurance. So we'll find out. Yeah, but anyways, this was his, right? Oh, no, that's not. That's all right. I'm going to close some of these up. We don't need them anymore. Be right back. Okay, so again, this is 2017, and I knew different things. I knew things differently then than I do now, and I would not even say I would do it exactly the same way as I'm going to show you. But I am going to say that, well, because we did this, this is why the rest of whatever happened happened. Right? It was because of what we said to the Supreme Court. Right? Because this is a misdemeanor copy, and so technically these 3 charges are no different than the ones Nate has today. So I'll go try it again, today and see if it works again. And at some point, try to get the Supreme Court out of the way, because I think what really needs to happen is you just need to file an exception and motion for acquittal and discharge. Because those are the things that are happening, right? Those are all based on definitions, and we're going to look at those in just a second. So, well, let's look at what we wrote based on this ticket. Right, so the United States of America, which of course that's the thing that's the entity in the Articles of Confederation, right? The style of this confederacy shall be the United States of America with the T capitalized. Where Billy Joe Roskin was a relator, right? He's speaking for the United States of America. And we sent it to the Chief Justice, Markman at the time, Michigan Supreme Court, get their address out of the website. And basically said, Chief Justice Markman, take judicial notice. I, Billy Joe Roskin, claim my civil liberties protected by the Constitution of the United States and Michigan are violated by individuals under Michigan Supreme Court's administrative control. I'm the victim of public wrong from which I demand relief and remedy and equity. I am denied due process of law and being secure in my person, papers, and effects. Probably should have said kept from being secure, but I get it. Now by the State of Michigan Uniform Law Citation, which we've looked at, and other documents that incorporate the ticket by reference are a simulated legal process under color of law. In a private tribunal having no share of the judicial power of the Michigan Republic. In the 64A Court of Ionia County is not a court of record of the state. Its style of process is not in accordance with MCL 614.14, and it has no authority to enforce state laws, administrative rules, local ordinances. I do not recognize this court's authority. It violates my civil liberties. An individual with officer's ID 3903 who initiated the use of ticket number 26018 omitted specifying the style of alleged violations, local ordinance, state law, administrative rule. Right, just real quick. Right, sure enough, they didn't do that because right about here, this person named above in violation of, right, they're supposed to check a box. They didn't check any. All right, so hey, it's an exception. All right, did not use proper legal citation for any such infraction. Instead, the alleged officer submitted a series of numbers in the simulation of proper legal citations. If assumed these infractions were against state law, then MCL 257-328 has the possibility of 1 year imprisonment, requiring a DC 225 complaint misdemeanor. See memorandum of Michigan Supreme Court dated June 13, 2013, and we even sent them a copy. Right? Send the Supreme Court their own stuff. There is no evidence the prosecutor initiated any such complaint or warrant. These individuals' actions are in violation of MCL 750-217C, which is a penal code violation in Michigan for simulating a legal process and impersonating an officer, as far as that goes. Right? So they had their say, we're having our say. In this ticket is to be considered an appearance ticket, then the alleged officer, 3903, omitted including a designated future time or local criminal court as defined in 764.9F appearance ticket. And it says what it means and so forth and so on. And all right, and the 64A Court of Ionia County is not a criminal court of the state, right? That's not a court of the state. So anything that these laws say, this court can't do because it's not the court is talking about. It's, a private tribunal acting as a state court. None of these people have taken the proper oath of office. They're not, they're not a constitutional state officer. So rebuke them as the devil. Unless the individual using the ID has been issued a numbered certificate in accordance with this other act, which was the Michigan MCOLS, Michigan Council on Law Enforcement Standards, or something like that. Right? They issue a certificate that proves that you passed met the standard to be a law enforcement officer. And you have to have that before you can be a law enforcement officer and issue any tickets. Well, none of these people ever produced one when asked. Right? An individual using the pseudonym, right, Kyle B. Butler, claims to be Ionia County prosecuting attorney. It's my belief there is no valid certificate of election that has been issued in accordance with Michigan compiled law, which is the election law for a prosecutor, in the name Kyle B. Butler. Right? So when somebody's elected, they're supposed to get a certificate of election. Well, what name is on the freaking certificate? Because this guy is saying he's Kyle B. Butler, but of course that's not his legal name. Right? It may be Kyle Brian Butler or something else, right? But he doesn't have an initial for a middle name. Right? So, but that's who he says he is. So either he's an imposter or he's an imposter. Because the name isn't going to match what's on the certificate. And so, Kyle B. Butler cannot be the elected Ionia County prosecuting attorney, especially since he didn't take proper oath of office. He's hiding his true identity. That's, that isn't what you would find on his driver's license. It'd be his full legal name. Well, if he has a real ID compliant, one with a little gold star in the upper corner, right, which is the whole reason for all that. So as a result, Kyle B. Butler is in criminal contempt of the Michigan Supreme Court. Yes, right? Now, here's the thing. They have a thing called a roll of attorneys kept by the Supreme Court. And people who have gotten them to send them will send them something that says these people are on the roll of attorneys for the Supreme Court. Every attorney is supposed to be on it. And on there, they'll be there in their full legal name. They won't be using the middle initial. Well, I take exception to that. So, Chief Justice Markman, your duty is clear as your obligation to take immediate superintending control of these individuals, prosecute their public wrongs, and see to my relief and complete remedy and equity for the harm done to myself, a peaceful inhabitant of the Michigan Republic. I await your affirmative action on my behalf. All right? That was all there was to it. One-page document. Let's just go ahead and send it. And I guess when I wrote it was the 5th. Now let's see what happened here. Well, they got it. You got a reply on the 10th, right, from the Michigan Supreme Court Office of the Clerk. Response papers we recently received from you addressed to the Chief Justice Markman. Your papers do not reflect. I have found no other evidence that you have a recent order or opinion of the Michigan Court of Appeals that could be the subject of an application for leave to appeal to this court. Now, again, we were writing directly to the Chief Justice of the Supreme Court, right? Because he, the Chief Justice, has superintending control over, justice in the state. Just like at local level, the Chief Judge of whatever court has superintending control over the administration of justice in his district. Right? So that's what we wanted to go to. And, he's making it sound we went to the court, which that's fine. I mean, this is, how they make it appear that nothing's happening. Your papers appear to relate to a district court matter. If you are dissatisfied with an order or opinion of a district court, you may appeal to the circuit court. If you're dissatisfied with an order or opinion from the circuit court, you may appeal to the Court of Appeals. If you're dissatisfied with the Court of Appeals, you may file an application for leave to appeal to the court under da-da-da. But that isn't what we were doing, right? We were just bitching to the guy who's supposed to have superintending control in his administrative hat, not in his judicial hat. Whereas here, Supreme Court review is available by filing an application for leave to appeal. A complaint for superintendent control may not be filed in this court. You got to see that right there. Well, we weren't trying to file in the court. We're trying to give it to, wrote a letter to the Chief Justice. But the interesting thing is that they marked it received and then returned. So they accepted it and then they answered it. Well, then we took that and we filed it in the court case. At least I think that's the one. I don't know if Billy filed this one in the court case or just a copy of it. But if I was going to go to all this trouble and send it to I would wait to get an answer back. It didn't take that many days to get an answer back. And, and then go file in the court case. But I'm hoping we don't have to do all this again. All right, we may do it in Nate's case. But I'm thinking if we just start with saying, well, we're taking exception, let's just file an exception and then motion for an acquittal and discharge. And, give it to the court and see what they have to say. All right, so that's what we did. And, from that, even though it sounds like they weren't going to do anything, when Billy went into court after that, and it may not have been the first one, it may have been the second, the next two, there were 3 hearings after that, because of what was, said in the first one, that the bailiff is no longer the court, bailiff that works for the court. It was the elected sheriff was in the courtroom as the bailiff. Which I think is, has to be telling for some reason. What does it take to get the elected sheriff to stand as bailiff in a courtroom for 2 afternoons, 2 weeks apart? Because that was all part of the show. Because one of the things that we brought up in the complaint that was filed with the court was the matter of venue. This court doesn't have any jurisdiction, it's the wrong venue. Okay, let's go look at just a couple more things in the transcripts. Hang on. I want to go through a few definitions right now. These are all out of Bouvier's Law Dictionary, right? So if you want to know where they came from. Discharge in practice. The act by which a person in confinement under some legal process or held on an accusation of some crime or misdemeanor is set at liberty, right? If you've been charged with misdemeanor, right, you're being denied your liberty. You may still be walking around, but you don't leave the state. The writing containing the order for his being set at liberty is also called a discharge, right? So you want to order, you've been discharged. Again, I'm trying to use their words. Whatever they say, okay, that's what we'll do. I'm just going to, try to, accomplish by doing every jot and tittle to pierce the veil. Okay, let's go down here. Okay, and then challenge in practice, right? It's an exception made to jurors who are to pass on a trial to a judge or to a sheriff. And the only part I was really interested in what it said about the judge, and it said interest forms the only ground at common law for challenging a judge. Right? That the judge of the 64A court, Ionia, whatever, it doesn't have any frickin' jurisdiction. I'm challenging the judge's jurisdiction. He doesn't have any interest in it because it's the wrong venue. Right? It is not a ground of challenge that he is given an option or given an opinion in the case before. No, you don't have any interest. Right? So keep that in mind. And then, but it did say what a challenge was. Well, it's an exception. So let's go look at exception. You got exception for legislation. You got exception for contracts. You got exception for practice and pleading. The term is used civil. In the civil, nearly the same sense as the word plea in the common law. In chancery practice, it's an allegation of a party in writing that some pleading or proceeding in the cause is insufficient. Well, I'd say this is what we're using it for because, the courts were combined. There used to be, in Michigan, you had courts of chancery and like circuit courts or whatever, and they combined it, made it into one court that has both chancery or equity and law, the ability to judge both. It's just that in chancery they use different words than they use in law. Right? So in chancery practice, it's an allegation of a party in writing that some pleading or proceeding is in a cause is insufficient. So, what do you call your document? Well, I guess you call it an exception. Now, they have a thing called a bill of exceptions also. And so, is that what I need to call it? Because that would be chancery, because bills are normally out of chancery, but they're not always out of chancery because they do bills out of the legislature also. Preemptory exceptions are those which tend to dismiss actions. Some relate to forms, others arise from the law. Well, we're going to bitch about, take exception to the forms. Right? That the form of the proceedings not proper. Bill of exceptions is a legal law. The definition of bill of exception is when a bill or a legal pleading is filed that is about a complaint on appeal that would not be on the record for the matter. The statement is concerning a disagreement that is given to a judge to look over and objects a decision that has been made. A certain form or amount of words is not needed on a bill of exceptions. Good. There's no certain form or amount of words you need to use. That's really good to know. Or you just need to say it's an exception. The trial court needs to know about the complaint by the information specifically stated in the bill of exceptions to be valid. Well, there you go, right? So you're going to use your bill of exceptions to bitch about what's happening to the judge, right? But it's not a motion. It's not an application. It's not a registration. It's a bill, right? Bills go to chancery court, go to the chancery side of the court. Bill of exception. The bill of exception can be used as evidence once it's in the records as such. The judge can sign and file a bill with the trial court clerk once all parties are in agreement with what is stated in the bill of exceptions. The purpose of the bill of exceptions is to question the law, specifically to make aware a mistake that has been made. So I guess the proper thing to do then is to file a bill and send a copy to the prosecutor, right, to give proper notice. One to the prosecutor, one to the judge, one to the court. With a certificate of, what would you call it, right, that you mailed them to them. Certificate of service. Right, and file that in the court. Bill may be used as follows. Allege an exception, praying that they will allow it. Now, praying could be a petition, but praying could also be a praecipe, which is something, it's a function of I want to say the chancery court or the clerk of the chancery court. That when you do a praecipe, it's asking the clerk to do something for you, which is file your exception. So I don't really know exactly what we're going to send. I'm just right now we're going through the idea, and by tomorrow we'll probably be sending something. Send something to the Supreme Court, and let's go file an exception into the court right now, and let's go try something. Can only be used in a civil case. Bill of exceptions does not have to be sealed by a judge in a criminal case. Okay, well, that's what we have. In New York, the defendant can file a bill of exceptions for the trial of any charge. Well, there you are. So we're going to do that. The bill needs to be signed, sealed, filed with the clerk of the court. Signed, sealed, and filed with the clerk of the court. What does that take to do? Exactly. If somebody could send me one and said, this is what a signed, sealed, and filed with the clerk of the court bill of exceptions is, I'd be really happy to look at it. You can send it to me, my email address, court of record at AOL.com. Not what you think one is, what one actually was, one that worked. Right? I want to see the proof, not somebody's idea, because I already got my own idea. Right? Go try your idea. If it works, well, then come back and show it to me. Okay, I'm more on Bill of Exceptions. So you can read all sorts about Bill of Exceptions. Or it's just called an exception, right? It's a formal objection to an action of the court during the trial of a cause in refusing a request or overruling an objection, implying that the party accepting does not acquiesce to the decision of the court, but will seek to procure its reversal. And that he means to save the benefit of his request or objection in some future proceeding. So basically, you're putting your testimony into the record. Okay, so I've already talked 50 minutes, and now I'm getting to these three transcripts, which are, let's see, this one's 28 pages, this one's 37 pages, and this one's 21 pages. So obviously we ain't going to get through all these. Right? I can't go line by line, obviously, but I just wanted to point out some of the interesting things that were said. Right, so for the people is Adam Dreyer. Right, and then they said they had an attorney for the defendant. I'll say he's on standby here in a little bit. Got a certified recorder. Where's the thing that? Who's who before Honorable Raymond P. Voigt for the defendant. Yeah. Witnesses, none. People had no witnesses. Defendant had no witnesses. There was no exhibits. So basically we're having a hearing with nothing there, right? It's all hearsay. There's no exhibits. There's no witnesses. There's just the defendant. And they don't have the defendant down as a witness for himself. But anyway, so a State of Michigan versus Roskin. Village of Lake Odessa versus Roskin. Well, could it be both? But that's what they said. We had a brief conversation in chambers. He's your standby attorney, so he's not his lawyer, right? He was just standby attorney, whatever that means. Unless you request he becomes your lawyer, and I would have to order that, right? Become your lawyer. He didn't say become your attorney. This is the thing. You don't want anybody to be your attorney. If they were your lawyer, that'd be a different story, because a lawyer is an attorney and a counselor at law, and you want the counselor at law part, right? You don't want it to be, act for you. You want them to give you legal advice, which is what the counselor does. But they always say you have an attorney. That's, part of the word game. But here he said lawyer. I mean, he used the right word. And then we're both ready to proceed. And the defendant says, it come to my attention, the officer isn't here because he had subpoenaed the officer. Right, I've subpoenaed him. Do we need him? I have questions. I'm looking at your motion. It's in the form of a letter. It looks like you wrote this to the Chief Justice of the Michigan Supreme Court. Right? So we know which one the court's looking at. And Billy's saying, there's two basic motions, one to dismiss and one for discovery. All right, what's the motion for dismiss? I guess I'm not seeing that. I have this letter that you wrote to the Chief Justice. Right? So he's telling what he's looking at, but Billy's not, going for that. He's going for these other motions that he put in. Right? I still haven't been shown a copy of the law that I've been charged against. I still haven't seen the oaths of office. Okay, this was all part of his discovery. So you've asked for a copy of the law or the citation. The law I'm being held against. Right? What's the law? The one cited on the ticket, the uniform ticket. The ticket isn't written in conformance with the citations required by the Supreme Court of Michigan. But I haven't seen any laws that have been violated. Have you looked them up? I haven't been presented with any laws. So you're saying no laws exist. Right? So, at that point you say, well, no, Judge, I'm not saying that. I said nobody's produced a law that I violated. The judge just doesn't want to admit that yet, but he's almost there. Right? You just need now to say, no, Judge, laws exist, and I haven't been charged with one. They need to be properly cited. The defendant, I was traveling, exercising my right to liberty, and I feel that I've been trespassed against. The uniform law citation doesn't cite any citations. There's no mark in the column at all. I'm looking at the ticket right now. Let me see if I can find a copy. Okay, and so this is where on the ticket, right, right above here where it says Freshwater Court, which was the name of the road, right, nothing's been checked. Right, that's the first thing. That's, basically his first exception. Right? There's nothing indicated on that line. Excuse me. It's my understanding to have a crime, you have to have a victim. And you can see in the upper right corner, there's no indication of a victim. And both the streets that are designated there are not relevant. The place where I was attacked was not Freshwater Court. It was not into the village, right? Because the cop, so this was, as I remember now, it was, the village cop that pulled Billy over, but he wasn't in the village when he got pulled over. Right? The guy, got behind him and everything outside of the village. So he was patrolling outside of his jurisdiction. So what are you asking the court to do? Right? And then I would like this case dismissed against me and reserve all my rights. And I'm saying, well, there is the place where you would say, right, I want an acquittal and a discharge of all charges. Period. That's what I want, Judge. I don't want it dismissed. I don't need to reserve all my rights. No, I want a fucking discharge and an acquittal of all charges. So technically, I think it has to be acquittal first and then the discharge, right? Because you get acquitted of all charges, then you can be discharged of all charges, right? So what are you asking the court to do? If you ever hear that question in traffic court, you need to say, I wish the court to give me an acquittal and discharge of all charges. That'd be the answer, right? So I like to dismiss. The court says, well, how about that, Mr. Dreher? He's the prosecutor. Your Honor, we just respond to that argument that venue is a question of fact to be determined by the trier of fact, which would be the judge. Right? Argument that venue is a question of fact. So this must be why they changed, because now the next time Billy would come to court, if venue had been the issue, he hadn't been arrested in the village. He had been arrested in the county, right, which the sheriff has jurisdiction over. Maybe that's why the sheriff showed up as the bailiff in the next two cases, because, venue had been brought up. Okay, any comments and observation? No boxes checked. It says person name above in violation of. There's either a local ordinance, state law, or none of the above. Prosecutor saying, certainly, Your Honor, we would argue that the village would argue basically that Scribner's error, I guess, or something along those lines. It's pretty clear that although the boxes specifically weren't checked, the actual citation does read, and it gives the numbers, right? 328, 225, all of which are listed in the offense code. Underneath that is, then they have these other numbers here, which, none of that makes any sense. Are those numbers appear to me, or my familiarity, to be a state law? Are those corresponding numbers on your village ordinance? It's my understanding that the village has adopted the Michigan Vehicle Code, right? So they just adopted the whole thing. Do you have a village ordinance in front of you? Not in front of me, Your Honor, but I will note that the citation does read people of the village of Odessa, so, it's the people of the village. Defendant, Your Honor, the court, I'm talking to him, okay? Is there any reason you cannot provide a copy of the village ordinance to Mr. Roskin? I'm going to print it out now, Your Honor. Right, so, let's provide him with the codes he's alleged to have violated. Mr. Roskin, I'm going to order that you be provided copies of each ordinance. You're going to be provided with copies of each ordinance. Okay, and they're enacted into law, the true copies. You don't believe that's the law? I don't know. It doesn't say. According to the Michigan Supreme Court, The designations have to begin with MCL, followed by the number, a dot, and the number sequence. Can I approach a bench? What for? This is a copy of what I was issued. All right. In my paperwork, I raised concerns of legibility. You can see the copy isn't even readable, and I wasn't given that at the scene. The court, you have a right to know what you're being charged with, and you're going to do that, and we're going to do that and do what we can to make sure that you know, or you're not being charged with anything. That the rest of that sentence. Then the defendant, the uniform law citation may not be used as a subject to for a prosecutor issued criminal complaint. When I asked for a true copy of the complaint, the lady downstairs told me the citation was the Supreme Court was. The Supreme Court says otherwise. All right, so this is the point about there needing to be another complaint, which hasn't been filed. If it hasn't been filed, there really shouldn't even be a court case yet. It's another exception. So the court says, you got any comment there, prosecutor? Well, Your Honor, going through the defendant's motion, as it relates to complaint and citations being used in lieu of complaints in traffic cases, traffic being a very specific type of case that this court would hear on numerous occasions and all sorts of various offenses, the citation is comparable to a complaint. So I certainly haven't been cited to any authority against that, but at the same time, if I may have a moment, I can pull the quote from the rule for that. So under Rule 6.615, misdemeanor traffic cases, it reads, misdemeanor traffic cases may be begun by one of the following procedures. The court, Mr. Rose, yes, he's listening. And under A, it says service law enforcement officer, defend a written citation, file a citation, district court, and I believe that the process has been filed in this case specifically, right? Now, again, filing of the citation. We saw that the only way to file the citation is by mail, and they're doing it by email. So, that would be another exception. Mr. Roskin, it appears that there's authority that allows the court to proceed with the citation under some circumstances like this. I was citing MCL 764-9F from the Supreme Court memorandum, which the prosecutor office also has a copy on. And one about 93-day cases, yeah, okay. I think this is a 90-day misdemeanor. 90-day, yeah, I don't think it applies to this case. Defendant, if you've been charged with a 93-day misdemeanor, for example, like a suspended license, I think you would be right. Well, he had been. Right? What he had been charged with, was this insurance one. And then, I think another one is not having a license. All right? 93-day misdemeanor. The defendant, I pled in the arraignment, Your Honor. Let me see, Mr. Wright, just to make clear for the record, Your Honor, the defendant has been arraigned on these charges. The court, yes. I pled in the arraignment, Your Honor. Right. Also, I'm informed by Michigan statute the proper jurisdiction over this matter is Secretary of State. Secretary of State has determined not to create a highway patrol. I'm looking for language here. Secretary of State shall not establish a highway patrol. So you're saying the jurisdiction is with the Secretary. Lost me, I'm sorry. Would you be more clear? Explain. Secretary of State would be hearing the case, not the court. Defendant, administer 257-204, administration enforcement of act, except as provided in this act. Secretary of State shall observe, enforce, and administer this act. Secretary of State shall not establish a highway patrol. Okay, so how does that fit into the case? It's Tom pretending to be a highway patrolman. Who? Tom Gogan. That was the cop, basically. He hasn't established himself as a police officer yet. And this goes on to the thing about the MCOL certificate. Right? So you can see it going on and on and on. I'm looking at the time. It's take forever to go through all this. Can't do it. I just can't do it. One thing I'm confident about and able to rule at this point is that police officers can enforce state ordinances, and that this officer, if it turns out that he comes to court and proves evidence that he's a police officer, is not an employee of the Secretary of State. So at that point, I'm not willing to dismiss the case based on that section that you're cited. Okay, so he is willing to dismiss it, just not on that particular section. Right? So again, we don't want to have it dismissed. We want to have, what's the word? Chief, I don't want to forget. Hang on. All right, we're going for acquittal. We're going to take our exceptions, ask for acquittal, and discharge. That's the plan. All right, here's another great one. They must have been all talking at one time. And so then the defendant says, I don't come to court. I also have to raise concern that Michigan compiled law 257.255 indicates that only enforceable by the state of Michigan, whereas in this case, the village of Odessa is pursuing the matter. The court, I'm looking at 255. So you're suggesting the village of Lake Odessa has no authority to enforce state laws? Yes, they don't. They have the authority to enforce the ordinances. And if they're going to incorporate the Michigan vehicle code as an ordinance, then there has to be an ordinance with the village that says that's what they did. And it can't just be a piece of paper. It's got to, been properly done, been sealed, ratified, homogenized, run up the flagpole, put on the frickin' bulletin board, whatever they need to do, right, to make it the public record to say this is an ordinance of the village. Not just that they were going to do it and talked about it a little bit, and we'll get at it, just sat in the clerk's office for the next 25 years. I'm not talking about that. I'm talking about the ordinance that's been done to say that that you have incorporated the entire vehicle code into a village ordinance. That would be the only way I could see that they could actually use, the village would have the authority to use the Michigan compiled law numbers as what they're charging. But of course, none of that's happened. None of this shit's happened. It's just what should have happened. And the judge is pointing it out, and he's given all sorts of great clues. All right, so the defendant, and this matter was actually outside the village territorial jurisdiction entirely. So you're indicating that if the officer had authority, he only had authority within Lake Odessa. Yes, yes, yes. Which would be a reason why he'd need to have her under oath, but have him here under oath. Right, that's the court saying, which would be the reason why he would need to have him here under oath. Yes, and that specific attack is only enforceable by the state. The court, even if it were to be a valid ordinance of the village of Odessa, only the state could enforce Lake Odessa ordinances. That's how I understood it. I'm not a lawyer. Well, I disagree with that, but I do agree that if the officer acted outside the jurisdictional of the limits of Lake Odessa, he would need to have permission of the state policeman or sheriff deputy to do that. There you go. Jeepers, it's so much here. All right, well, because I'm tired of reading, hour and 10 minutes in, I'm going to go to the last paragraph of the final transcript, where the court says, as I was saying, there's a lot of things that Mr. Roskin says that I don't even understand where he gets them from. Clearly, honestly believes them, whether reasonably is debatable. In my opinion, it's outside the mainstream, outside of what's expected. But what is true is that the government does get its authority from the people. The burden of proof is upon the state, and the state is held to a higher standard as it relates to prosecution. We were here on January 6th to continue a motion that were filed in April, and frankly, I let the people off the hook on that day. Mr. Roskin let the people off the hook. I was ready to dismiss that day, right? This was way back in April. right? The one I was reading from the beginning. He was ready to, at that day, and give the prosecutor a specific outline of what they needed to do to get the case together and have it ready for today. And it's not. We still don't have a complaint. We still don't have a discovery complied with completely until it was just tossed on the desk right here. And that's not at standard I'm going to hold the standard that I want to hold the government to. The government needs to be held to a higher standard because the government is a servant of the people, not vice versa. So I stand by my decision. This case will be dismissed with prejudice. And then just really quickly then, in the in-betweener, right, because there was one in April, then one on June 6th, and one on June 12th. Well, on June 6th, what happened at the beginning was the prosecutor said, Your Honor, I haven't had an opportunity to speak directly to Mr. Roscoe, and however, I did speak to his standby counsel and provided an offer in exchange for his plea of guilty to a non-ops in possession. Now, remember, in the pleas, you can plead deny, right? So just plead deny. The people of the village of Lake Odessa would dismiss with no valid plea. He would serve 6-month non-reporting DSA sentence. However, it's my understanding not wish to make such an offer. Make use of such an offer. Today, however, the officer unavailable, right? So the officer didn't show up the second time either. And he had been told to before. So another exception. And then we get to the court. Defendant, yeah, I'm here as a man. I'm here as my own person. I ask you want to represent yourself. I am myself, Judge. I me, myself, and I. Okay, I want to continue to do that. You have the right to do that. All right, so are we ready for trial? Now the court's asking, are we ready to go to trial? So your position on going to trial Friday, are you ready to go to trial? I still haven't seen any oaths of office. I haven't seen any law. I haven't seen the officers. Neither one is here in the court. I'd like to see it. So what do you want? So what should I do? What would you like me to do? Being asked again, right? This one's time to stop arguing and say, well, Judge, I want an acquittal and discharge of all charges. Period. An acquittal, that's the proper thing for a malicious prosecution, right? So it's good to have a call an acquittal because if they acquit you, then you had been maliciously prosecuted. Where if they dismiss you, that's just a temporary summary judgment. You want an acquittal, right? So what he said, I would like to see it permanently discharged. That's good. Right? I just think that you have to have it acquitted first and then you're discharged. But, he should have stuck to that because we're going to go back to, being dismissed in a little bit. So I would like to see it permanently discharged. Good for you, Billy. I don't understand how we can continue without certified copy of law. I've asked it and asked. None of the citation, the face of this uniform law citation, represented anything I've discovered to be proper. I've discovered to be proper citations for the statute, a law, or ordinance, or even a code. I've been to several local governments. They will not show me any copies of the law, even if they're official law copies they're supposed to have kept available for me. You've been to the village of Lake Odessa? I've been there multiple times. And my paperwork, you see, I've written them. I've talked to the court. I've written the village manager. I've asked the court respectively, to issue warrants to discover these laws. The prosecutor has been ordered to discover these laws. Nobody has to date produced the law. Then the attorney, the prosecutor steps up and said people did provide the defendant with a copy of local ordinance adopting motor vehicle village ordinance. Hang on. Okay, just one little part here then. The court said, I'm going to talk. I've seen situations where lawyers have raised these sorts of issues. For example, whether a municipality, village, township, city has properly enacted or endorsed a law. And we've had to dig into the city records and discuss that. Those are issues that are not to be raised or are to be raised ahead of a trial. They're not to be raised at the trial. And we don't want the jury to hear this stuff. I don't want to raise these types of issues in front of a jury. I see we do have some citations. I don't see where a complaint has ever been filed if I'm properly reading the file. And then I think we also talked about police officers coming to testify today. Prosecutor, that's correct, Your Honor. Defendant. 2, you ordered 2 officers to be present. I do recall that. Are the officers available? Mr. Dreyer, prosecutor. Not today, Your Honor. The court, well, Mr. Roskin, I'm willing to dismiss, but the dismissal wouldn't be permanent. To which Billy said, well, that's my fear. This prosecutor already told you. He told me he will refile. Right? So if you get it dismissed, they're going to refile. Well, what did the order say that excuse me, the judge could do? Acquittal or dismissal. We're just asking for the wrong thing. We're on the wrong side of the slash mark or hash mark. All right, so that that pretty much sums it up. Is that's what's going on. And well, after all that was done, they gave Billy a dismissal, which held. They didn't ever go back and do anything again. Right? They stuck with the dismissal. I'm just saying, you want to get an acquittal, not a dismissal. So that would be the plan over the next few days, is to try this again and see exactly what happens. But it's not just a traffic case. This would be in any kind of civil case, right? That when you see that they're not following the law, you need to ask or call it an exception and ask for an acquittal. We'll have more of that in a future episode. But hey, traffic ticket story hour is over. Fact, fable, or fantasy is yet to be determined. But the moral of the story is you do want to have an exception and an acquittal and a discharge. If you can get the 1, 2, 3, right, you will have pierced the veil. So that's what I'm all about. I want to pierce that veil. Everyone have a great 4th of July, and thank you, Vet. See you now.